judgment in the appeal Dunhill and Burgin.
Lady Hale will explain the judgment of the court.
There are two issues in this case. First, what is the test for deciding whether a person lacks the mental capacity to conduct legal proceedings on her own behalf? In which case, the civil procedure rules require that she has a litigation friend to conduct the proceedings for her. Second, what happens if legal proceedings are begun and settled or compromised without its being recognised that one of the parties lacked that capacity, so that she didn't have the benefit of a litigation friend and the settlement was not approved by the court as also required by the rules? In June 1999, Ms Dunhill was struck by a motorcycle driven by Mr Burgin when she was crossing the road. She suffered a severe head injury. In May 2002, she issued a claim against him for damages limited to £50,000. On the day of the trial, Ms Dunhill, on the advice of her lawyers, agreed to settle her claim for £12,500 plus costs, and this was embodied in a consent order which was put before the judge. In fact, this was a gross undervaluation of the very serious injuries which she had suffered. In 2006, she consulted new solicitors. A litigation friend was appointed to act on her behalf, and an application was made to set aside the settlement on the ground that she had lacked the capacity to make it and it should have been properly approved by the court. Mr Burgin's insurers were understandably concerned that a claim which they had thought settled long ago might be reopened, even though they had had no reason at all to think that Ms Dunhill lacked the capacity to make it. Indeed, they argued, her remedy should lie against the legal advisers who had underestimated the claim from the start and advised her to accept such a low figure. As to the first issue, the test for capacity, the parties agreed that this means capacity to conduct the litigation. But Mr Burgin argued that this meant the claim as actually formulated, in which case she did have the capacity to conduct such a simple action. Ms Dunhill argued that it meant the claim as it should have been formulated, in which case it was agreed that she did not have the capacity to conduct a much more complicated action. The High Court judge held that it meant the former, so he dismissed the application to set aside the settlement. But the Court of Appeal held that it meant the latter. This meant that the case had to go back to the High Court to decide whether the settlement should be set aside for failure to comply with the rules, or whether the normal law of contract should apply, under which a contract made by a person who lacks capacity to make it can only be set aside if the other party knew or ought to have known of the incapacity. The High Court judge held that the settlement was subject to the rules requiring it to be approved, and so should be set aside. Mr Burgin appealed to this court against both judgments. On the first issue, the Supreme Court agrees with the Court of Appeal. The test of capacity to conduct proceedings for the purpose of the civil procedure rules is the capacity to conduct the claim or the cause of action which the claimant in fact has, rather than to conduct the claim as formulated by her lawyers. Otherwise, her capacity would vary according to whether she had good lawyers or bad lawyers or no lawyers at all, which cannot be right. On the second issue, the Supreme Court also agrees that the settlement should be set aside. Ms Dunhill should have had a litigation friend at the outset of the proceedings. The court does have power retrospectively to validate steps taken without a litigation friend, provided that it is just to do so. While it might be just to validate steps along the way, it could not be just to validate a settlement finally disposing of the claim, which ought to have been properly approved by a court. Indeed, the court had not been asked to do so. The civil procedure rules had long provided an exception to the ordinary law, which was justified by the need to protect children and people without the capacity to conduct their own proceedings, not only from themselves, but also from their lawyers. Mr Burgin's appeals are therefore dismissed and the case must go for trial.